Oh, no doubt, Christine and Maurice. But at this moment, as we understand things, the ruling means that immigration and visits to the U.S. from those 7 mostly Muslim nations can resume right away. A federal judge in Seattle has halted the executive order by President Trump from a week ago. Washington, the first state to sue over the order to block travel. Tonight, the judge said it's not the court's job to make policy, but it is the court's duty to determine if an order, even by the president, complies with the Constitution. In this case, the judge says the ban does not meet the test.
Am I concerned that Homeland Security will not follow the judge's ruling? No. We're a nation of laws. It is absolutely my expectation that the federal government will honor this ruling by this judge today.
Here is the most precise sentence about Trump's relationship with the federal judiciary in his second term. He rages in public. His lawyers comply in court. That split, public fury and private retreat, is the documented behavioral pattern across every major judicial loss this administration has experienced. Trump calls judges rogue. He demands an end to judicial overreach. He promises to get around rulings he doesn't like, and then his legal team files the compliance brief. That pattern is not weakness in the traditional sense. It is a specific political strategy. Generate noise on the political track while accepting constraints on the legal track. But it has a cost. The rulings the legal team quietly complies with are permanent. They accumulate, and the noise eventually has to answer to the record.
With huge protests at airports across the country, including JFK, as some travelers were detained. Before the judge's ruling tonight, President Trump reiterated his stance, tweeting, quote, "We must keep evil out of our country." And just minutes ago, Press Secretary Sean Spicer tweeted, "The ban is intended to protect the country, and they believe it is lawful and appropriate." Live in the newsroom, Jessica Layton, CBS.
Subscribe and leave a like, because the Donato collective bargaining ruling, the 3-0 appeals panel with a Trump appointee in the majority, and the Boasberg pound sand language are worth understanding precisely in that context. The 2017 Seattle clip is the historical anchor. A federal judge halted the original Muslim ban executive order. Sally Yates, then acting attorney general, said on camera, "We're a nation of laws. It is absolutely my expectation that the federal government will honor this ruling." She was fired days later for refusing to defend the ban in court. The executive order was ultimately revised and partially upheld. But the judicial confrontation pattern that clip captures has not changed in 9 years. It has accumulated. The Donato ruling is the most practically significant ruling in the document for the specific people it affects. Chief Judge James Donato permanently blocked Trump's executive order ending collective bargaining rights for more than 1 million federal employees. The finding: the administration was punishing unions that opposed Trump and attempting to wipe out long-standing labor protections in a way that violated the law. 1 million federal workers permanently blocked. CNN reported it. The workers whose collective bargaining rights were targeted by the executive order are the same category of workers the administration's economic populism brand claims to champion. The judicial protection of those rights, through a permanent block, not a temporary stay, and is the legal system doing exactly what the Yates clip described. The government must comply with the law, even when it's the government. The 3-0 appeals panel on indefinite detention is the same pattern at the immigration enforcement level. A specific detention policy of whom holding migrants indefinitely without bond hearings was struck down as beyond what the law allows. One of the 3 judges in the majority was a Trump appointee. The same dynamic the IEPA ruling and the 9-0 due process ruling established at the Supreme Court is operating at the circuit level. Judges appointed by Trump applying legal principles and reaching conclusions the administration dislikes. The Trump appointee dimension is worth precision. Appointing judges does not produce loyalty. It produces jurists who apply their jurisprudential methodology to the cases before them. When that methodology, applied consistently, reaches a conclusion the appointing president dislikes, the judge has done their job correctly. The expectation that appointed judges should deliver politically favorable outcomes is the same misconception Trump expressed when he called Gorsuch and Barrett fools and lapdogs after the IEPA ruling. The Boasberg pound sand framing is the most direct language in the document and deserves careful treatment. Chief Judge Boasberg of the Federal District Court in D.C. refused to allow the administration to evade judicial oversight of 137 migrants who had been effectively removed from the country, sent overseas in a way that made them unavailable for the asylum proceedings the court was overseeing. Boasberg ordered them returned or allowed to file asylum claims. His language, according to the document's characterization, made clear that the administration cannot evade judicial review by quietly shipping people out of the country. The specific mechanism being blocked, removing people from U.S. jurisdiction to avoid court oversight, is an evasion strategy rather than a compliance strategy. The court found it unacceptable and said so directly. That directness is the judicial equivalent of the contempt findings this series has documented in the merchant gag order proceedings. Courts draw clearer lines when they find the administration is not just testing limits, but actively evading oversight. The pound sand language reflects a judicial assessment that the specific evasion at issue was not a good faith compliance attempt, but a deliberate effort to make judicial review moot. The birthright citizenship challenge is the pending case that this document correctly notes is likely to fail at the Supreme Court. The 14th Amendment's citizenship clause, all persons born or naturalized in the United States, has been interpreted for over a century as granting birthright citizenship regardless of parental immigration status. The administration's challenge to that interpretation is before the courts. The document's characterization of the Supreme Court as likely to reject the challenge is consistent with the constitutional text's weight and the long-standing precedent. The federal reorganization halts, described in NPR and CNN reporting, are consistent with the APA challenges this series has documented throughout. Agencies cannot be restructured or abolished through executive action alone. Reorganizations that eliminate statutory functions require statutory authority. Funding freezes that override congressionally appropriated funds raise constitutional questions about the appropriations power. Courts finding the administration overstepped statutory authority in these areas are applying the same clear legal authority principle the Supreme Court established in the IEPA ruling. The public fury and private compliance pattern has a specific electoral consequence. Every time Trump attacks a judge publicly for a ruling his lawyers then quietly comply with, he is simultaneously demonstrating two things to two different audiences. To his political base, the judiciary is politically motivated, the rulings are unjust, the resistance continues. To everyone else, the rulings stand, the compliance is real, the legal constraints are operative regardless of the social media response. The 5 competitive seats run through districts where both audiences exist. Members calculating their November position have to decide which message to amplify and which to acknowledge. The Sally Yates clip said it in 2017, "We are a nation of laws." The rulings since then, across 2 terms, have been the legal system's answer to what that means in practice. The Donato ruling's specific legal finding, that the administration was punishing unions that opposed Trump, is worth developing because it is a more precise allegation than simple policy disagreement. If a court finds that an executive order was issued with the purpose of punishing political opponents rather than advancing legitimate policy objectives, it is making a finding about motive that has specific legal consequences. Government action taken in retaliation for protected activity, including union organizing and political opposition, is subject to heightened constitutional scrutiny and may constitute viewpoint discrimination against organizations based on their political positions. Donato finding that the collective bargaining order was designed to punish unions that oppose Trump is not a finding that the policy was unwise. It is a finding that the policy was issued for an impermissible purpose, targeting organizations based on their political opposition to the president. That finding, if upheld on appeal, is a more fundamental constitutional problem than a simple statutory authority question. The million-plus federal employees whose collective bargaining rights the order targeted are not abstract numbers. They are people who negotiated contracts, who have grievance procedures, who have organizational structures that represent them in dealings with federal agencies as employers. The permanent block preserving those protections is the judiciary applying constitutional principles to protect a specific group of people from what the court found was politically motivated retaliation. The same workers whose protections were targeted by the order are the same category of workers the economic populism brand claims to champion. The court's protection of their rights is the legal system performing the function the political brand promised and then attempted to undermine. The Boasberg proceedings are the most documented thread in this series, and the 137 Migrants episode is worth placing in the full context of what the series has established about those proceedings. This series documented Boasberg's contempt findings, the administration's good faith compliance arguments, the deportation flights that continued while the court proceedings were active. The 137 migrants who were effectively removed from U.S. jurisdiction to avoid court oversight represent the most acute version of the evasion pattern this series has been tracking. Courts maintain jurisdiction over immigration proceedings for specific individuals. When those individuals are removed from the country during active court proceedings, the court's jurisdiction over their cases becomes practically difficult to exercise. The administration's strategy, we remove people before the court can act, is designed to make judicial review moot by eliminating the subject of the review from U.S. territory. Boasberg's response, order them returned or allow asylum filing, is the court asserting that its jurisdiction cannot be mooted through executive action. The administration cannot eliminate judicial oversight by eliminating the people the oversight was protecting. That assertion of judicial authority over executive evasion is the specific constitutional confrontation the pound sand language describes. The Boasberg contempt proceedings, the good faith arguments, and the 137 migrants episode are all part of the same documented pattern, an administration testing whether judicial oversight can be made practically ineffective through operational choices rather than legal arguments. The court's consistent response, "This is not effective, comply," is the record this series has built. The public fury, private retreat patterns, political mechanics deserve more development because they describe how the two tracks, legal and political, interact without directly engaging each other. When Trump attacks a judge publicly for an adverse ruling, he is not making a legal argument. Courts do not change their rulings because the president posts about them on social media. The attack is directed at his political audience, the base that needs to understand each judicial loss as persecution rather than accountability. The attack maintains the persecution narrative that makes every adverse outcome evidence of the conspiracy against him. When his lawyers file the compliance brief, they are not engaging with the public attacks. They are acknowledging that the legal system has made a determination that the court has authority and that the administration is bound by the ruling regardless of what the president says publicly about it. The compliance is the legal track acknowledging reality, while the political track generates a different narrative for a different audience. The gap between those two tracks is where the accountability story lives. The legal track produces permanent documented rulings. The political track produces narrative that manages how those rulings are received by supporters. Both operate simultaneously and neither directly cancels the other. The courts do not care about Truth Social posts. The political base does not read compliance briefs. The two audiences receive entirely different information about the same judicial outcomes. What eventually forces the two tracks to intersect is November. The electoral outcome will be shaped partly by which narrative, judicial accountability enforcing the rule of law or rogue judges persecuting a strong president, reaches more persuadable voters in the 5 competitive seats. The rulings are in the permanent record. The compliance is documented. The attacks are documented. All three are available for voters to evaluate. The Sally Yates clip as historical anchor deserves more development because it establishes the specific constitutional principle that every subsequent ruling has been enforcing. Yates said in 2017, "We're a nation of laws. It is absolutely my expectation that the federal government will honor this ruling by this judge today." She was fired for refusing to defend the Muslim ban. The executive order was revised and partially upheld in subsequent litigation. But her statement that the federal government honors judicial rulings described a norm that 9 years of subsequent litigation has been testing. Every compliance brief filed after an adverse ruling is a confirmation of that norm. Every evasion attempt, shipping people overseas to avoid court oversight, delaying compliance while seeking emergency stays, pursuing alternative legal theories after rulings block the primary theory, is a test of that norm's enforceability. The norm has held imperfectly. Courts have found contempt. Courts have ordered returns. Courts have issued permanent blocks. Courts have required due process. And the administration has, after the legal options are exhausted, generally complied while maintaining on the political track that the compliance is unjust. Yates was fired for insisting on the norm. The norm she insisted on has been enforced, case by case, ruling by ruling, through 9 years of subsequent litigation. Both things are simultaneously in the permanent record: the firing of the person who insisted on the norm and the enforcement of the norm she was fired for defending. The Trump appointee dimension of the 3-0 panel is the same analytical story as Gorsuch and Barrett in the EPA ruling, but operating at the circuit level rather than the Supreme Court level. It is worth developing because it describes a systemic feature of judicial independence rather than an isolated incident. When a president appoints judges, they select from a pool of lawyers whose jurisprudential philosophy is generally compatible with their political coalition's priorities. Trump appointed judges from lists vetted by the Federalist Society, conservative textualists and originalists who prioritize limited government, separation of powers, and deference to statutory text. Those principles, applied consistently, sometimes produce rulings that constrain executive power. Textualism asks what the statute says. If the statute does not authorize indefinite detention without bond hearings, a textualist judge reading the statute finds no authorization. Originalism asks what the Constitution meant. If the Constitution's due process requirements applied to all persons when ratified, an originalist applies them to all persons today. A Trump-appointed judge who finds the administration's detention policy exceeded statutory authority is not betraying the appointing president. They are applying the judicial philosophy the vetting process selected for. The outcome that conflicts with the president's political preferences is the price of appointing principled jurists rather than loyal agents. That is what judicial independence looks like at the circuit level. The same case-by-case application of established legal principles that produced the IEEPA ruling is producing circuit-level rulings across immigration, labor, and administrative law. The pattern is not coincidental. It is the judicial appointment process functioning as designed. Last thought, connecting the accumulated judicial record to the accountability arc. The document lists 9 years of judicial confrontation: the 2017 Muslim ban, the first term immigration policies, the second term IEEPA tariff ruling, the Donato collective bargaining bloc, the Boasberg 137 migrants order, the 3-0 indefinite detention panel. Each is a separate case, each is a separate ruling. Together, they describe a 9-year documented pattern of courts applying constitutional and statutory principles to administration policies and finding specific violations. The pattern is not the judiciary is biased against Trump. It is that the administration has repeatedly tested specific constitutional and statutory limits, and courts have repeatedly found those specific limits exceeded, sometimes unanimously. Sometimes with Trump appointees in the majority, always with compliance briefs filed after the noise subsides. The permanent record is what accumulates. The political noise is what fills the space between the rulings. November measures what the accumulation produces. The 5 competitive seats, the member survival calculations, the suburban voters processing competence and stability signals. The judicial record is one of those signals, not the only one, but a specific and documented one that describes the administration's relationship with the legal system it is supposed to operate within. Sally Yates said it in 2017. The courts have been enforcing it since. One more observation on the birthright citizenship challenge, because it is the pending constitutional case whose outcome this document predicts and whose stakes are the highest of any second-term judicial confrontation. The 14th Amendment's citizenship clause, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. The administration's argument challenges the long-standing interpretation that subject to the jurisdiction thereof excludes children of undocumented immigrants from birthright citizenship. The argument is that undocumented immigrants are not fully subject to U.S. jurisdiction, and therefore their U.S.-born children are not constitutionally entitled to birthright citizenship. The counter-argument, which has prevailed in every circuit court that has addressed it, the 14th Amendment was specifically designed to establish unambiguous birthright citizenship after Dred Scott, and the subject to the jurisdiction clause excludes only foreign diplomats and enemy combatants, not undocumented immigrants who are fully subject to U.S. law in every other respect. The Supreme Court's likely rejection of the birthright citizenship challenge, as the document describes, would be the most significant constitutional ruling of the second term for its long-term demographic implications. It would also be the most complete application of the clear legal authority principle to an administration claim, finding not just that a policy exceeded statutory authority, but that the constitutional text itself forecloses the interpretation. The case is pending. The document's prediction is that the court will reject the challenge. If accurate, it would add one more ruling to the accumulated record, not a constraint on a specific policy tool, but a definitive constitutional statement about who is an American citizen, and what ending his term actually means, since the title invites the question. No judge is ending Trump's term. No ruling removes him from office. No court has issued an order that terminates his presidency. What courts are doing is drawing specific constitutional and statutory lines around what the administration can do during the term. That is categorically different from ending it. The distinction matters because conflating judicial constraint with removal produces the same analytical error as conflating all 9 ruled against him with the court turned against Trump. Courts constrain specific actions. They do not determine who holds the office. The Constitution determines who holds the office, and the 22nd Amendment and the election calendar determine when terms end. What the accumulation of judicial rulings does is narrow the space within which the administration operates during the remaining months of the term. The EPA tariff authority is eliminated. The collective bargaining order is permanently blocked. The indefinite detention policy is struck down. The deportation evasion strategy was rejected. Each ruling removes a specific tool from the administration's operational toolkit. That narrowing is consequential. It shapes what the administration can accomplish in the remaining months before November. It shapes the political environment within which the 5 competitive seats races are run. It shapes the record that the electoral measurement will encounter. But it is constraint, not termination. The administration continues. The term continues. The political and policy work continues within the specific limits the courts have drawn. The distinction between constraint and termination is the analytical precision the headline sacrifices for drama. The documented reality of specific judicial constraints is significant enough without the termination framing.